Hello and welcome to this video on the fundamentals of patents. My name is Dr. Mannan and I will be walking you through this video. In this video, we will learn the fundamentals of a patent, such as what is meant by a patent, why a patent is granted, and how a patent is granted. At the end of this video, you will be able to define patent, describe the significance of patents, describe the basic process and the timelines for obtaining a patent. Patents are considered to be one of the most important IP rights for a company. Patents generate significant value to a company in terms of income earned and expenditure saved. Patents are granted for inventions. An invention is a technical solution to a problem. Invention should be capable of being exploited in an industry. Patents are granted for new and non-obvious inventions. A product or process is protected by a patent. Patents are legal rights granted by the government of a country through its patent office. A patent application comprising a detailed description and claims of an invention are required to be submitted to the patent office. After examining the patent application, a patent is granted to the owner of the invention. Patents are territorial IP rights granted for inventions for a period of 20 years in most countries. The territorial rights are applicable within the boundaries of a country. There is no such thing as an international patent. Patent rights exclude others other than the owners from making, using, selling and importing the patented product or process producing that product for those purposes. Patents can be sold or leased much like an immovable property. However, a patent can be leased to many parties simultaneously. Patent essentially contains the constituents as shown on your screen. The first page contains essential information such as patent number, date of publication, title, inventors' names, owners' names known as assignee of the patent, date of filing, classification codes, references cited, abstract and a drawing. Field of the invention indicates the broad technical field to which the invention belongs. Background of the invention describes the previous developments related to the inventions and a problem the invention is poised to solve. Summary of the invention describes the essential features of the invention, their interactions, their functional relationships, and the way the problem is solved by the invention. Detailed description contains a lucid explanation of the diagrams and different variations or embodiments of the invention. Claims. Claims are the most important part of a patent and they describe the features and functions of the invention in a legal framework. Claims are interpreted with the help of the detailed description and the diagrams. Claims are critically analyzed by the examiners of a patent office before the grant of a patent. An infringement of a product is decided by comparing the claims with the features and functions of a product alleged to be infringing the patent. We will see the significance of patents in order to understand why they are considered to be one of the most important IP rights. Patent rights can be sold or leased for commercial considerations. Patent holder has the right to initiate legal proceedings against an unauthorized user of the patent. Punishments range from impounding of infringing goods, penalty and compensation to be paid to the owner of the patent. Patents can increase the value of a company many times over. Patents create an exclusive and dominant position in the market for a patentee. Patents signify advances in technology. With the selling or leasing of patents, technology transfer and dissemination takes place, thereby enhancing the overall development of technology. Patent rights conferred by the government are an incentive for an inventor to disclose the complete details of the invention. If the inventor prefers to keep it as a secret, there can be no further development. Patent system assures an economic reward to inventors in exchange for the disclosure of knowledge. Patent publications contain a great wealth of technical and scientific knowledge in public domain. Researchers and scientists can study and apply this knowledge for further development. Industries that cannot afford to pay licensing fee for a particular patent may wait for the patent's lifetime to expire and develop the product for selling in markets domestic or foreign. An example is the manufacturing of bulk drugs by small and medium scale industries in India for export to US and Europe. While a patent is made to work, a few problems may be encountered, and the solutions to such problems can result in more patents. On the other hand, while trying to find a workaround for a patent, the researchers may explore new ideas that can be patented. Patent laws encourage creation of new products and technologies that enhance the quality of life. Some examples of patented technologies that enhance the quality of life are automobiles, computers, handheld devices, internet and healthcare solutions, to name a few. New processes enhance industrial development and large-scale manufacturing. Thus, scientific and economic development of a country are enhanced by patents. We will now see a generic procedure for obtaining a patent and timelines for obtaining a patent. An invention is an idea or a technical solution to a problem. An invention that is new and non-obvious can be patented. An organization or an individual can apply for a patent. Many organizations have laid down internal processes for selecting and patenting valuable ideas. An internal process for selection of inventions for patenting is explained in another video. A patent application with the mentioned contents is drafted based on the description of an invention. Patent drafting is done by skilled professionals known as patent attorneys or IP counsels. Patent application is filed in a patent office by attaching necessary forms, paying the prescribed fee and getting a receipt. This is known as first filing or priority filing. The filing date is important and the date of priority is quoted in all the subsequent filings in foreign patent offices. The validity and life of a patent will be claimed from the priority date. A patent application can be subsequently filed in a number of foreign patent offices. A patent application has to be filed and granted in each and every patent office for enforcing it within that particular country. The process of first filing and foreign filings are depicted in the diagram shown. The point to be noted here is to strictly avoid a publication of the invention in a journal or conference before the first filing to avoid your own publication affecting the novelty of your invention. Further procedure in a patent office is listed as shown. An examination can be requested by paying additional fee at the time of filing a patent or within the prescribed time limits. On an average, it may take 2 to 4 years from the date of filing for getting a patent granted in a country. In this video, we learnt that patent rights are a set of exclusive rights granted by the government to the owner of an invention. The patentee is required to explain the invention and submit a patent application in a national or a foreign patent office. The patent office conducts an examination to make sure whether the patent is new, non-obvious and industrially applicable before granting a patent. A publication describing invention has to be strictly avoided till the first application is submitted in a patent office. Now that you have learnt about the fundamentals of patents, you can attempt the case study. Once you have read the case study and answered the questions, view the video on debriefing the case study.